This issue is before me on the motion of the state to admit evidence pursuant to Rule 404B of the South Carolina Rules of Evidence, and also under the theory of res geste. Of course, the defendant is on trial for murder of his wife and son. And over the course of the past several days, we have conducted an extensive in-camera hearing. The court has reviewed all of the exhibits submitted and I've considered
It's coming in.
the testimony of each and every witnesses, and I have concluded that the motion should be granted. Under the law of this state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. An exception, however, exists when the evidence is offered
Trial just
to
got
show motive.
weeks longer.
I'm God. Well, it was nice to meet you, God. Thank you for the Grand Canyon, and good luck with the apocalypse. Oh, and by the way, you suck!
Identity, the existence of a common scheme or plan, the absence of mistake or accident or intent. And
or
before
motive.
Admitting this evidence, the court must
Or motive,
first
which is the big
determine
one that
if
you
it's
just missed.
relevant.
Good job.
Our rules define relevance as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the case more probable or less probable than it would be without the evidence. After determining relevance, the court must determine if the evidence falls within an exception to Rule 404. In determining if an exception exists, the evidence must be logically relevant to the particular purpose or purposes for which it is sought to be introduced.
We had
This
zero
requires the court
testimony
to
or
analyze
argument in
whether
favor
a
of.
logical nexus exists.
The nexus is pretty thin.
Evidence is logically relevant when it reasonably tends to prove a material fact at issue. And of course, the evidence of any other crime offered to be admitted into evidence or proven or testified to
Must be proven by clear and convincing evidence. And the court is to conduct and required to conduct an analysis.
So good news, everyone. We get to hear all that testimony
403,
again because the
which
jury
weighs
gets
the
to hear it, which means
probative
we
value
get to
versus
hear it.
prejudicial effect. According to the state, the nexus is supported by the unusual circumstances of the murders, in that the defendant was the last person to see his wife and son alive, and
one who discovered the bodies.
Well, that's an open question,
all in a
isn't it, Your Honor?
relatively short period
Yeah,
of time.
we actually don't know that at all.
The state has presented evidence in this in-camera hearing, evidence of numerous financial crimes allegedly committed by Mr. Murdaugh.
Okay.
The state argues that the logical nexus between the murders and other crimes
I mean, it's terrible. This is going to take an extra 2 weeks now. But
is
on the
that
other hand, I think the
looming
defense can spin this in its
exposure
favor.
of financial crimes
Sure, that's possible.
provided motive for the murders and is evidence of malice.
They must have argued that in a written motion.
Of murder.
also received testimony from Mr. Carson Burns, the Attorney General's office, who traced funds in and out of the bank account. I find that the jury is entitled to consider whether the apparent desperation of Mr. Murdaugh.
What apparent
Because
desperation?
of his
Yeah, really.
dire financial situation.
That wasn't testified to.
The threat of being exposed for committing.
We just got testimony from all these other people who knew about the
which
financial
he was
crimes.
later charged with. While motive is not a necessary element, the state must prove malice, and evidence of motive may be used to prove it.
The malice is
In
the
this
execution
case,
shots
since
to the head.
identity of the
Yeah, that was easy.
perpetrator is a
Critical element that must be proven beyond a reasonable doubt. Evidence of motive may be used in an attempt to meet that burden. This evidence of other crimes is admissible and it's non-propensatory, as it does not suggest to the jury that the defendant has a tendency to commit murder.
I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground.
Really?
Or
Really? You sure about that
brand
one?
Specific charge.
Thus, it's not Thus, it is non-propensatory evidence and supported by state law. Therefore, this non-propensatory evidence of other crimes is admissible under Rule 404B and Rule 403, and that the evidence, which may be prejudicial,
but it's
The jury
more
has no idea. They just
probative
got another 2-3 weeks
than
added to their
prejudicial.
sentence.
Yeah, because
As
not
to
only are we going to
raise
get the
gestation,
testimony that we
alleges
got,
that
we'll get
Mr. Murdaugh was under
additional
immense
testimony
pressure
from all
after
those
being
witnesses.
confronted about
An
the missing
additional
fees,
cross.
Additional cross, yeah.
the upcoming hearing on the motion to compel his financial information, his dire financial straits, and looming exposure of this criminal activity.
Now it's actually in the defense interest to make it look as
Contends
horrible
that,
as possible. These people lost as much money as possible.
That situation led
Suggest alternative
to the
people. Yeah.
murder of
I will, for the record, when it's offered, just make a formal objection to protect the record. Your
Yes,
Honor,
sir. I understand.
Showing no disrespect to the court.
No, I understand.
If he had limited it to this particular check, if he had limited things that occurred on that day, he'd be in a much better legal posture. But if he's going to have a completely open inquiry into, let's talk about all the financial stuff, no matter when it happened. It's all res
it's a whole second
gestae.
trial.
I'm like, it's like, come on.
It's a whole second trial within a trial.
Eh.
The state's motion to admit the other evidence or evidence of other crimes is admitted. I will file a more formal order
Written order.
granting the state's motion later.
It's a big
today.
ruling. That's a big ruling.
Are
The
we ready for
defense
the
is going
jury?
to object. So the defense is ready for that. That's appropriate. The defense had to know this ruling was coming. This judge has signaled that this was going to be the way that they would rule. He has made a very thorough record because this is grounds that cases get overturned on. Cases get overturned on allowing in prior bad acts to prove that somebody did this bad act. The judge has ruled it's not more prejudicial than probative. So the witnesses that we have heard in 404 will be coming in this trial, and there is an instruction that will tell them that that evidence alone is not sufficient, but it will go a long way towards how the jury sees this case and the circumstances of this case. The judge laid it out thoroughly. The judge will put this on the record because if Alec is convicted, this is going to be one of the biggest grounds for appeal. And that is something, again, I'm going to just reiterate myself, this is a grounds that cases get overturned on. So the judge needs to make a thorough record. It's why he allowed all of these hearings, so that the appeals court would have a record of how and why the judge made the decision that he made. He is allowing it in. I think he is right in that. I think the defense has very much taken the tack of this person couldn't do this, and the prosecution has a right to rebut that.
All evidence of financial crimes that may likely have led to a motive, will lend itself to motive for the crime committed. And that may be before or after.
Yes, I understand the court's ruling. I will, for the record, when it's offered, just make a formal objection to protect the record. Your
Yes,
Honor,
sir, I understand.
Showing no disrespect to the court.
No, I understand.
He's doing.
Okay, you
That
ready for
was
the
a
jury?
State's ready to proceed,
Say
Your
it.
Honor.
Bring them on.
Bring them on this morning instead of bring the jury. That's a big ruling from the judge, and the prosecution needs to be careful. They need to make sure that this does not become a trial on the financial crimes, but remains a homicide trial. This, at the end of the day, is a murder trial. And if the prosecution overwhelms the evidence that they present on the financial crimes and not on the murder, it leaves them very open on appeal. Then again, appeals, are for losers. So if the state does not convict Alec Murdaugh, there's no grounds for appeal anyway. So that is a balance that they absolutely have to strike. This is common evidence that comes in. It is not substantially unusual. It's just that balance needs to be careful on how much you bring in.